Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We're here today for oral argument. We're going to begin with Appeal 24-2275, United States versus Stephen Dorfman. And we'll begin, Mr. Swanson, with you.
May it please the court?
Yes.
Counsel. My name is Nathan Swanson, and I'm here today on behalf of Appellant Stephen Dorfman. Appellant Dorfman was convicted of 1 count of conspiracy to commit wire and mail fraud, 8 counts of wire fraud, and 4 counts of mail fraud following a jury trial. Dorfman raises 4 counts of alleged error on behalf of the district court. Now, unless there are any specific questions, I was going to proceed somewhat out of order and take up the second point raised by appellant, mainly because there is a difference of opinion as to what happened. Point 2 argued that the trial court erred with regards to the government's Exhibit 10, that government's Exhibit 10 had not been admitted and therefore never should have gone to the jury. If you look to the record, the actual transcript of what happened in court that day, it's clear that the Exhibit 10 was never admitted. It was never offered. There was no opportunity for the defense to object or consent to its admission, and the trial court never ruled that it was admitted. There's no magic, the case law is replete with the statement, there's no magic words for admission. But you still have to offer evidence. It still has to be brought up in open court, there has to be the opportunity to challenge it, and it has to be ruled admitted. And that didn't happen here. The minute order does say Exhibit 10 was admitted, but the minute order is not signed by the judge. It's supposed to be descriptive of what happened. Errors can leak in there. The exhibit list, that's filed at the end of the trial, after the trial is concluded, after the jury's returned their verdict. Again, it's descriptive. It says this is supposed to have been what happened, but it doesn't substitute for the admission of Exhibit 10. You have to look to the record. Was there a stipulation that Exhibit 10 was admitted? No, there was a stipulation that Exhibit 10 consisted of a business record, so that wouldn't have been a legitimate objection, but that doesn't mean that every objection had been waived.
I thought the stipulation was that Exhibit 10 was admissible.
I believe the stipulation was that it was a business record of Simple Health, Your Honor.
And so what objection would Mr. Dorfman have posed with regard to admissibility had he challenged it at that time?
Well, and that's part of the problem is we don't know because it was never offered. But if you're asking me to...
Well, I think it's a dispute about whether or not it was offered. I'm just asking you, kind of assuming that it was expressly offered and assuming that Mr. Dorfman objected, given the stipulation, what would be the basis for his argument that it's not admissible?
Beyond the simple relevance or prejudicial effect, there were also hearsay statements of non-parties contained within the recording. It was approximately, I want to say it was 4 hours, certainly several hours of recording, including not just Mr. Dorfman speaking, but other people in the audience asking questions, talking amongst themselves. But even beyond that,
And your contention is that the stipulation doesn't cover those statements?
Yes, Your Honor. The stipulation would be that it was kept as a business record of Simple Health for that purpose, but no other objection was waived by that stipulation. And to proceed, even if there hadn't been any objection to it, here's the other problem with the admission, the fact that it wasn't offered and wasn't accepted. The defense never has a chance to respond to it. They've never had a chance to put it into context, to cross-examine it, to refer to it, because it's not clear that it's been admitted. If they don't know that it's in evidence, they can't address it, they can't rebut it, whatever it might happen to be. Then it goes back to the jury. Now, again, the case law is replete. Evidence that hasn't been properly admitted shouldn't be submitted to the jury. And how the trial court handles that is they're supposed to determine first, was the jury actually exposed to that evidence? If it's sent to them, did they see it? And then, because the rule on this is clear that you can't inquire into the jury's actual deliberations, the judge is supposed to examine the exhibit to see what prejudicial effect it might have had. There seems to have been no question between the parties or the trial court that the jury was exposed to it.
How many total exhibits were there that went back to the jury?
The record seems to indicate all of them were sent back to the jury, and there were several hundred. What they reviewed, obviously that's a little bit more problematic. There was allegations made by the defense that they reviewed this exhibit in particular, but given the nature of this case where there were several hundred exhibits that were admitted, they're all provided. I believe the record indicates that a laptop with all of them on it was provided to the jury. We don't know which ones they viewed, but certainly they got all of them.
You're relying on this minute entry, but the district court also found that the courtroom deputy was in communication with the parties, discussed the joint exhibit list, which is consistent with how I think most trials proceed. Why wouldn't we defer to that factual finding?
Well, you're saying the factual finding that the courtroom clerk was in conversation.
Mm-hmm.
So certainly I don't think there's any question about that. I think defense counsel conceded that every day at the end of trial they were having conversations with the courtroom clerk. But what was not in that factual finding was specifically that the courtroom clerk discussed with the parties Exhibit 10. And this kind of gets us into the unknown problem here, which is if and the record doesn't, the co-defendant's counsel says, okay, as to 5, 6, and 7, let's just agree not to object and move on. If they don't know that the court clerk is considering Exhibit 10 admitted there, they don't have any grounds to stand up and object to it. They don't have any, knowledge necessary to say off the record at the end of the day, wait, hold it. Exhibit 10, you're saying Exhibit 10 is in. No, it wasn't. We don't know what conversations were had there. The defense counsel said, this was kind of the argument that defense counsel made at the motion for new trial. How do you object that something wasn't offered and admitted if you don't know that's being considered admitted? This might be different to your point about the factual finding. If there had been a factual finding that parties, you discussed Exhibit 10 and didn't raise that objection at the time, then certainly that would be something else. That would be something that would be granted some deference. But that finding wasn't theirs. That the practice of the court was to talk about evidentiary issues. You can't talk about an evidentiary issue you don't know exists yet. And that was when counsel for the co-defendant pointed out during the motion for new trial hearing, that he didn't even realize these minute orders were being published every morning. Hadn't reviewed it, didn't find out until later.
If we could move you to the first set of arguments about the Thompson case. In Thompson, the statute at issue there just used the term false. The wire fraud statute uses false or fraudulent. Couldn't that latter phrase, fraudulent, encompass half-truths or omissions?
Oh, certainly. I think that was the point of Nader. That was the point of, that's well established. But I think equally well established is that those half-truths, those omissions, they have to be material. And the materiality part, that's what's missing from government's proposed instruction number 2. It simply says that a scheme to defraud doesn't just require false statements. It also can be accomplished by the order of the words or the circumstances in which they're said. But you notice that in the government's proposed instruction number 2, the word material never appears. It's never stated in that instruction that this misinterpretation, this misleading impression, whatever it happens to be, from the order of the words or the circumstances they're given, that must be material. The problem with this government's instruction number 2 is that it's essentially orthogonal or standing apart from the rest of the instructions that say scheme to defraud has to involve material omissions, material misrepresentations, material fraudulent statements. And I think this is consistent with this court's finding in Weimer. It's not just you say something that gives a false impression to the victims of the fraud. That false impression has to be material. That instruction number 2, if that's taken as an accurate statement of the law, then the result in Weimer isn't appropriate, because in Weimer, he certainly did give a false impression to the quote-unquote victims there. It just wasn't a material false impression.
I think the hurdle, though, that argument faces is that we have to consider the jury instructions as a whole, and certainly there are a number of other instructions where the jury was told that that the fraud or fraudulent pretense, representation, or promises had to be material. So why doesn't that address the issue of materiality that you're raising now?
And that's why I use the phrase orthogonal to kind of describe it with instruction number 2. The other instructions, they fit together. They provide, it can be a misrepresentation, it can be false, fraudulent by omission, as long as it's material. Instruction number 2 stands apart from those. The concern with instruction number 2 is that even in context with the other instructions, that the jury could read this and conclude the scheme to defraud could be accomplished either by material misrepresentations or by giving a misinterpretation of the circumstances or misrepresentation or some such like that, just because we have a misimpression of what's happening.
But wouldn't, to Judge Lee's point, wouldn't that directly conflict with other jury instructions? I mean, the jury instruction said a scheme to defraud is a scheme that is intended to deceive, etc. It said by means of a materially false or fraudulent pretense.
And certainly I agree, but then they are also told that a scheme to defraud, or that a scheme to defraud can be accomplished by the order of the words, and they don't say material there. In Woods, the case that the government relied on here, I think it's notable that there was also an instruction in Woods when the jury was told whatever misrepresentation there was, false statement, fraudulent misrepresentation, omission, anything of those, what we call the facts, they must be material. That instruction tied it all together for that jury, no matter which one you're finding. Is it omission? Is it commission? Misrepresentation, misimpression? All of them have to be material. And there's not a corresponding instruction here to tie them all together.
You want to reserve the remainder of your time?
I will, yes, please.
Very good. Thank you, Mr. Swanson. Mr. Reed will now move to you on behalf of the appellee.
Judges, and may it please the court, Peter Reed for the United States. I'll also start with that second issue regarding exhibit number 10. I'd like to make 4 points about exhibit number 10, 2 going to why a reasonable person could have come to the same conclusion that the judge did here, and 2 going to the harmless error standard under Rule 52. Starting with the abuse of discretion. When you look at the trial transcript here, there are 4 reasons why a reasonable person could have come to the same conclusion as the district judge did here, that the government was admitting government's exhibit 10 and that government had come into, or that exhibit came into evidence. The first is that counsel for the government said, I intend to introduce 5, 6, 7, 9, 10, and 12. The second is defense counsel then responded, if these have already been stipulated to, let's move along, right? And I think that first part is important. If they've already been stipulated to, let's move along. The government had just said, these are the 6 exhibits that have been stipulated to. The response is, if these have been stipulated to, let's move along. And so defense counsel then says 5, 6, and 7. And I think this is where the defendant's argument, the hook for the defendant's argument, because certainly the first part of defense counsel's answer suggests all 6. But he goes on and says 5, 6, and 7. And I think that what matters here is the body language and tone. The judge was in the courtroom. The reality is that the judge, the court deputy, the government's counsel, they all understood defense counsel to be saying there was no objection to the full set of exhibits. And this made perfect sense. They were all stipulated to. They all involved the same subject matter. They were all involving the sales training. And so third, the government counsel responds, if there's no objection, we move these exhibits in. Again, these exhibits were understood to mean all 6 by both the court and by the government and the courtroom deputy. And fourth, the government indicated that it understood that all 6 had been moved in, because as soon as he says these exhibits, he says, if those are in, I'll sit down. It's in the context of previously saying that he planned to introduce all 6 exhibits in this set into evidence. These 4 contextual clues are more than enough to support the standard of review on appeal, which is whether a reasonable person could agree with what the district judge did here. The second point I'd like to make—
Mr. Reed, what do we make of the fact that no one referenced Exhibit 10 at all at any point during the trial? The government didn't raise it, the defense didn't raise it. It's just kind of this kind of zombie exhibit out there. Is that relevant to our analysis at all?
Judge, I think it's very relevant to the harmlessness standard. An exhibit that's admitted but not played for the jury, not mentioned in closing arguments, not relied upon at all by the government, is classic harmlessness. And I think that's the first point on harmlessness. This is a classic example of harmlessness, because as you say, the government's not relying on this. It's not mentioned in closing. And those are the kind of things that this court typically looks to when it's determining whether a purported error is harmless or not. Here, there's no reliance on this exhibit all the way through. I think there are additional reasons why this is classic harmlessness. If you look at Exhibit 10, it's a video of the defendant, Mr. Dorfman, giving the PowerPoint presentation that came in Exhibit 6. The entirety of the presentation is in a different exhibit. It's just who's presenting it that is different in Exhibit 10, and I think that's part of the explanation for why Exhibit 10 didn't end up being played. The content of that exhibit was already into evidence. If I may, a second point on harmlessness is what this video goes to, I think, if I'm reading the defendant's brief right, is intent to defraud. And the government introduced extensive evidence of intent to defraud. I'll briefly just highlight some of those, but that's what 2 weeks of this trial was about. So harmlessness is first going to be what impact could this exhibit have had, and I think it's a classic example of harmlessness because it wasn't even relied on by the government, but also, on the flip side, there was extensive evidence of intent to defraud. There were the blatant lies in the online ads, which falsely suggested that this company was selling ACA-compliant plans from major carriers. You can see those ads on page 7 of the appellant's brief. There was the sales scripts themselves, which contained those 6 fraudulent statements that Dorfman personally wrote in an attempt to defraud his customers. Third, there was the use of the 2-script system, where they would use a different script when HII was present, when they were being monitored, because they didn't want third parties to recognize what they were doing. Fourth, there is the deceptive customer service and cancellation practices. One example I'll highlight, Exhibit 462. HII is highlighting 5 problems with what Simple Health was doing at this time. 5 major problems. One of those was the need to accurately describe the product. One of those was the need to be clear that the product is not ACA compliant. And Dorfman's response is, how about you shove 90% of that shit up HII's ass for me? There's just overwhelming evidence that Dorfman was trying to defraud these victims and of his intent to defraud. And this additional exhibit, to Judge Brennan's point, there's over 450 exhibits in evidence. One more drip in that ocean of intent to defraud evidence is just not making the difference here. I could go on intent to defraud, the daily drop-off reports, the bad retention rates, the decision to lie to HII about whether they were recording calls because they didn't want HII to know that they were defrauding their customers, the decision to buy burner phones so that they could artificially inflate their BBB rating because their customers so hated the way they had been defrauded that their BBB rating was terrible, the way they decided to lie to state investigators about some of the same issues. It's all intent to defraud. An enormous amount of evidence of intent to defraud in this case. So if I could go back actually to the first part, there are 2 reasons why there's no abuse of discretion here. The first is that context. But I think there's a second point here that this appeal illustrates very well, and it's made by the Third Circuit case in Small, which is the burden is on the parties to check what exhibits are in for this exact reason. And anyone who's been through a trial knows that you're neurotic about making sure that everybody's on the same page. You check at the end of a witness. You check at the end of the day. You check at the end of the next day. You check at the end of every day of trial. You check at the end of the government's case over and over and over again. And those opportunities were presented here to talk with the courtroom deputy. What exhibits are in? And if at any one of those points, defense counsel had said, wait, what about Exhibit 10? Any issue could have been remedied. It would have been easy to do so. Again, it was Dorfman's own statement. There's really no possible grounds to suggest that this evidence was not admissible. And that's part of why it was stipulated to as a business record.
Mr. Weed, I'd like to move you to the question of the jury instructions. And it's a question about the provenance of the jury instructions. It seems like the key instruction here had its genesis in United States versus Woods,
Yes.
which is a Ninth Circuit decision, 335 F. 3rd 993 from 2003. Now, we all know Thompson had it was from this court, went to the Supreme Court, it's come back. How does Woods become the basis for the instruction that gets into this trial?
Right, so Woods was a telemarketing case, frankly. This is an instruction that was developed for these kind of telemarketing cases where you have a long script that is designed as a whole to be misleading and deceptive. There are a number of instances, and it's outlined in the brief, specific instances that build on each other for why this is deceptive. And so prior to trial. This telemarketing case is out there. It provides an instruction for this kind of case, and so that's why it gets pulled in here. I think the second part of your question is about Thompson, and Thompson, of course, comes later after Woods. It's really not, its use here isn't really connected to Thompson one way or the other. But I think Thompson really clarifies why this instruction is correct. 1014 is a very different statute than the fraud statutes. And if I understand opposing counsel correctly, he's not necessarily objecting to the content of this instruction, which I think is supported by the Seventh Circuit's cases. And really, a lot of this language is 60, 70, 80 years old and across multiple circuits. He's really arguing about whether the word materiality should have been repeated in this instruction. And I think this court's cases are clear that instructions are read as a whole. They aren't read separately, individually. They're not individual constructs. They're read as a whole. The jury is presumed to follow them, and here the jury had a materiality instruction. It's presumed to have followed that materiality instruction, and there's no reason to think that they didn't.
Could I ask you a question specifically about the jury instruction? What does it mean when an arrangement of words or the circumstance in which they're used may create an appearance which is false or deceptive? That
Yes.
word appearance seems kind of like a strange word in this context, right?
Right. So I'd say two things, I think, about this, maybe two examples of this that would be helpful. That are specific to this case. And again, this language about an arrangement and appearance is very old language. I cite some of the case law in my brief. It's from the Third Circuit. It dates back, I think, to the 50s, 60s, 70s. But I'll give two examples. The first is before the customers get transferred to the sales representative, they've seen two different things. They've seen an advertisement, and that advertisement typically said, buy Blue Cross Blue Shield, or buy Aetna, right? Or they saw an ad that said Obamacare enrollment, okay? In the background of those experiences, they were then directed to a website that says, get quotes from 15 top companies, okay? They then go to an to a Simple Health sales rep who says, I'm here representing major carriers. The sales rep statement is a different statement, right? But it has to be read in the context, the appearance of those earlier statements. And I think that's what we're getting at when we talk about the arrangement may create an appearance that is false or deceptive. The whole point of the ads and of the lead website was to create an appearance that they represented these companies so that when they reached the sales rep, they assumed that's who they were talking to. And they weren't talking to a rep from one of those companies. That was false. A second example, I think, is what's referred to as the doctor's visit exhibit in the script. And so the script uses this example where they say, suppose you have a doctor's bill that's $200, you get the contracted rate and it marks down to $70 and you get $50 off. So you end up paying, in this example, $25 on $200, right? When you look at the exhibits, these were random numbers. There's actual exhibits of executives in this company saying, well, if we said zero on a $200 bill, that wouldn't be believable. So what's the lowest price we can give that's believable but also sells a lot? There was no contracted rate for $70. It was completely made up. But the argument from defense was that this example was technically true, right? Because, well, yes, if you got it, the maths, right? Yes, if it was a $200 bill, and yes, if it got marked down to $70, and yes, if you got a $50 payment, you'd pay $25. But there are assumptions baked into that. You're creating an appearance that you pay $25 on a $200 bill, when that just wasn't the case. The numbers were made up. And so you make that statement with the intent that the listener thinks, oh, I'll pay $25 for a doctor's visit. Nonsense. The numbers were made up. The math might check out, but it didn't reflect reality. If there are no further questions.
No, thank you, Mr. Reed. Mr. Swanson, we'll now move back to you for rebuttal argument.
Just very briefly, with regards to Exhibit 10, I have to argue somewhat with Mr. Bershman. The actual statement of defense counsel was, if we've already stipulated to Exhibits 5, 6, and 7, just not object to move on. He was very clear. If we've stipulated to those exhibits, 5, 6, and 7, not 9, 10, and 12. If he had meant to include those, he would have. He didn't. The other point I would make is that the government pointed out it's the burden of the parties to determine what exhibits have been admitted. That goes both ways here. The government's arguing that defense counsel should have stood up and said, wait, hold it, you didn't admit Exhibit 10. That burden falls equally on the government to say, wait, hold it, did I admit Exhibit 10? That, they could have raised it too, and it still would have been resolved. To say that defense counsel has to object that exhibits weren't admitted, but the proponent of the exhibit is the one who carries that burden. It's the government's burden at the trial. I'd also point out, as to the harmlessness analysis, Judge Lee, you pointed out, this was never referenced again. Certainly, when the judge got to the prejudice portion of the analysis, that might have been relevant, but he also would have to review the content of the exhibit. When you look at the cases, Barry and, I'm probably butchering how this is pronounced, but I think it's Sabubu, but I'm not entirely sure. Those cases all talk about, first determine, was the jury exposed to it? Well, you could look at the record and conclude that if government had argued it or they had played it. But when it's something that wasn't admitted and therefore should not have gone back, you have to actually check with the jury to see if it was. If they seem to have assumed that, but it wasn't clearly on the record. And then going to the argument with regards to government's proposed number 2, again, Judge Lee, I think that question about the appearance kind of gets to the heart of this. The examples that the government uses, if they give a misunderstanding to the consumer, you're going to get a $50 copay. You're going to get 30% off. Okay, fair enough. That is absolutely a material misrepresentation, and to the extent their scripts were doing that, that would be problematic. But they changed those scripts to say up to, this is an example, hypothetically, all of those things. Those give the impression that this is a good deal, this is a valuable product. And that may have been a mistaken impression. You or I might not want to purchase it. But that's puffery. Puffery is not sufficient for fraud. So when they say appearance, they're broadening substantially beyond material misrepresentations, materially inaccurate, fraudulent statements, whatever it happens to be, to just misleading representations, misleading impressions. That is much, much broader than what the fraud statutes reach. And if there are no other questions.
Thank you, Mr. Swanson.
Thank you, Your Honor.
Thank you, Mr. Reed. The case will be taken under advisement. We're going to move now to Appeal 25-2565, Wisconsinites for Alternatives to Smoking versus Casey. Mr. Fraser, we're going to begin with oral argument from you.
May it please the court. Your Honors, I plan to focus my comments this morning on the first preliminary injunction factor, likelihood of success on the merits, but I'm obviously happy to answer any questions on the other 3 factors. The district court erred as a matter of law in finding that 21 U.S.C. 337A does not impliedly preempt a state law which seeks to enforce the FDCA's pre-market tobacco authorization requirements for new tobacco products. Section 337A says that only the federal government can bring actions to enforce the FDCA with one exception for certain food products. The district court acknowledged that Section 337A impliedly preempts state law, which seeks to enforce FDA requirements for other FDA-regulated products, such as drugs, foods, and medical devices. But then the district court decided that Congress intended to carve tobacco products out of 337A because in 2009, when Congress amended the FDCA via the Tobacco Control Act, Congress included a clause that preserved the state's rights, historic police powers, to prohibit the sale of tobacco products. The problem with the court's analysis is that all products that are regulated under the Food, Drug, and Cosmetic Act are products for which the states have historically had police powers, including the power to prohibit the sale within their state's borders. I think this is most directly seen if you look at the original Food, Drug, and Cosmetic Act passed in 1938. That original statute had what is now 337A that said only the FDA or only the United States can enforce this act. It also had a pre-market approval requirement for drugs. In order to market a new drug in the United States, you had to submit an application to the FDA and show that the drug was safe, and there were other requirements. There were no preservation clauses in the original FDCA. There were no preemption clauses, express preemption clauses in the original FDCA. But no one would have argued at that point in time that because FDA had set up a pre-market approval requirement, that Congress had stripped the states of their historic police powers to regulate the sale of drugs within their borders. This was demonstrated just earlier this year in 2025. The Fourth Circuit in the Gen Bio case that we cited in our briefs dealt with a West Virginia statute which bans the sale of the abortion pill, which FDA has approved. And the manufacturer for that drug made a preemption argument, implied preemption, saying that, well, the FDA has approved this drug, so you're encroaching on the FDA's authority. And the court said, well, the Food, Drug, and Cosmetic Act leaves to the states the authority to prohibit the sale of products within their borders.
Counsel, that brings up a point. There you had the federal government approving a drug and the state coming in and taking a contrary position. Here you have products that arguably violate a federal regulation being sold. And in the first instance, we need to look at our jurisdiction.
Sure.
In HARP advertising, we held that a village ordinance that prohibited a particular sign didn't cause a plaintiff concrete injury because a separate ordinance still would have prohibited the sign. Do we have a problem with jurisdiction here in the sense of redressability if these products are prohibited regardless of any action by the district court below?
I don't think so, Your Honor. So it's clear that our clients are being injured by this statute. They are unable to sell products that they were able to sell prior to this point in time. I think when analyzing this issue in the context of the Food, Drug, and Cosmetic Act and jurisdiction, the court needs to recognize, which the district court did as well, that the FDA exercises enforcement discretion in a lot of different areas. There are a lot of products on the market today, probably within 100 feet of this courthouse at a store, that do not comply with the Food, Drug, and Cosmetic Act. If you go into any CVS, there are over-the-counter drugs that are not in compliance with the law. Saying that a party cannot be injured in a legal dispute over its ability to sell those products would really create a problem in terms of jurisdiction and redressability for all sorts of products. I'll give you an example. The FDA, because of problems with baby formula supply in the United States over the past few years, has exercised enforcement discretion and allowed products from overseas to be brought into the United States, even though those products don't comply with the FDCA. Under the state's theory here, you could have somebody suing under a supply contract that they didn't get what they were promised under the contract, and the defendants could say, well, you know, the products aren't legal anyway, so you haven't been injured. You don't have the right to get these products. I think in the context, when we're not talking about, when we're talking about FDA-regulated products, I think trying to set up a jurisdictional test which requires, in the district court, I like the way the court described this, is, I don't know if it was perfection with federal standards or whatever. You could often find some problem. Believe me, I know the FDCA really, really well from my prior experience. You can always find a violation with an FDCA regulated product. And I think trying to set up a jurisdictional test at that level is just unworkable.
Counsel, going to 387P, the preservation clause, preemption clause, savings clause, the preemption clause prohibits a state or one of its subdivisions from establishing a requirement that is different from or in addition to. What's notably absent is identical to. And there seems to be some cases that talk about when there's concurrent jurisdiction to enforce the same standard, that doesn't necessarily raise the type of preemption concerns that there might be if the state were trying to enforce a different standard. Here, I think the argument has been made that, in fact, the state is trying to basically enforce the same standard that the FDA is requiring. What is your best authority for the argument that implied preemption is appropriate even when the state standard mirrors or is identical to the federal standard?
I think the authority I would rely on, Your Honor, the cases we cited at page 28 of our opening brief. Those cases deal with medical devices. And the Food, Drug, and Cosmetic Act has an express preemption provision for Class 3 medical devices that uses the same language that is used in the express preemption provision here. And if you look at the cases we've cited there, what the courts have said is, okay, you can get past that, the preemption clause, and the state's standard is identical, but then you have to look at 337A and say, would this still be a violation of state law if the FDCA did not exist? So what the courts have done in those cases is they have prevented the states from doing what the state is trying to do here, which is say, well, we know we can't enforce this provision of the FDCA, so we'll just make a mirror image of it and enforce it that way, which at the end of the day makes 337A meaningless and cannot be what Congress intended when it passed 337A. I think I want to focus, or I don't know if the state and...
So I'm sorry, if I could just follow up
Yeah.
on that. So let's assume, as a hypothetical matter, that the FDA announces tomorrow that it's adopting a new policy where, somehow it got all this incredible funding from Congress and that it now has the resources to go and enforce every single violation of the TCA where there's no pre-market authorization, okay? In that instance, would the implied preemption doctrine still apply because of 337A? Would that be your argument?
I believe it would, Your Honor. Our position and the position of the United States in filings it's made in amicus briefs is even when the FDA has enforced a provision against a particular party, the FDA considers it to be a violation of 337A if another party then comes in and tries to bring a follow-on action to enforce the same provision. Because when the FDA enforces, it has a range of options as to what it will do to those parties that are violating the statute. And it does a bit of analysis and it really thinks about what it's going to do. It's not a one-size-fits-all punishment or resolution with that defendant. So that's the way the FDA has interpreted it. They see that as a problem if other parties are coming in to piggyback on what the FDA is doing. And as we put in our reply brief, I think that's what Justice Stevens, I think he had the view or the kind of the position that would allow what you're proposing here. But that only got 2 votes. I mean, the rest of the court didn't go along with that. So I don't think that would change the calculus. And it wouldn't change the calculus, Your Honor, because when you look at and we've cited in our briefings, the letters that the FDA sent to the International Trade Commission in 2023 and to R.J. Reynolds in 2023 make clear that the FDA is constantly changing based on conditions on the ground what its enforcement priorities are. So the FDA could go after all those problems. And I think the point...
The difficulty, though, that the concern I have with that, and perhaps you can educate me on this, is that it seems like you're saying that the state statute might conflict with FDA's kind of prosecutorial discretion or the way it wants to prosecute these cases. But it seems like preemption, we're looking at statutes and laws and regulations and things that have the effect of law. If we just rely upon prosecutorial discretion, then wouldn't basically everything be preempted? I mean, I think that's kind of the point that the Fifth Circuit was trying to make in is it the Zeiler case? Mm-hmm. That
Zeiler.
It's if you ground preemption on this notion that you might interfere with the way the government prosecutes things, then that just casts a preemption, not just too broadly. And I was wondering what your response to that is.
I disagree with that, and we disagree with the Zeiler opinion, which is before the Supreme Court right now in cert, and we'll see what happens with that. The problem here is that that's not we're not talking about a situation where the state, like some states, as is noted in the briefing, have just decided they're going to ban flavored vaping products. You just can't buy them, no matter what the FDA does. And that is not preempted because that is not basing its decision on what the FDA is doing. So this does, to your point, Your Honor, what you said, maybe tomorrow the FDA announces that it's got all this money and it's going after everyone on the market. I highly doubt that. I don't think that the FDA, and I'm not talking about the money, I don't think if the FDA had a magic wand today that would just take every flavored vaping product off the market, it would do that. Because that would be a disaster, because the FDA knows that that's going to drive some people back to combustible cigarettes, which are more harmful than vaping products.
So that you reserve the remainder of your time?
Yes.
Thank you,
Your
Mr.
Honor.
Fraser. We'll now move Ms. Gibson to you for oral argument on behalf of the appellee.
Good morning, Your Honor.
Good morning.
The district court got it right in denying the preliminary injunction here, and we ask the court to affirm that today. First, I'll just touch briefly on standing. This is not a case like the baby food formula case that they've relied on in the briefs, where the FDA made a considered explicit decision not to treat a product as illegal because there was a national shortage of baby formula and they needed to expand the universe of products available to consumers. Here we have no factual evidence in the record to support that any of the hundreds of products that they would like to sell are actually things that the FDA wants to see sold. And we've got lots of good evidence in the record that the FDA's approach in 2024 and 25 in particular is the opposite. The FDA does not want these products on the market. They're seizing them, tens of millions of dollars in several seizures just over the last year. And they tell retailers and manufacturers right on their website, there is no safe harbor. So the whole factual premise of this non-enforcement is not supported by the record, and that affects two parts of the case. It affects standing because their theory that, well, we're not perfectly complying with the law, but that shouldn't affect our standing, that's not your factual scenario here. This product is flat out illegal under federal law, no matter how this case comes out. So the cases they talked about in their brief, like Iowa and Farm Worker, where if the plaintiffs could just win, their conduct was totally legal, that's not the scenario here. And that's why there's no Article III jurisdiction. Moving on to the Tobacco Control Act.
But under that rationale, no one would have Article III standing where a statute mirrors federal standards. Isn't that right?
I guess it would be hard to imagine what the claim might be. I mean, to the extent
Because
Your Honor's talking
the
about
argument will
preemption
always
claim.
be that they don't have a right to produce it because they don't meet the federal standards, and therefore they can't challenge our state statute on preemption grounds.
Sure, I mean, they have different remedies. One thing they'd be able to do is go to state court and raise preemption as a defense. Remember, preemption's not a basis for federal jurisdiction on its own anyway. So they can raise it as a defense in a state court enforcement proceeding if that ever were to happen. Obviously, they can challenge whether the FDA should have approved the product, and we know there are lots of petitions for judicial review out there by vape manufacturers who want more products to be approved that the FDA is, as we saw from the Wages and White Line case this April, is en masse disapproving. So going to the Tobacco Control Act, which I understand why the appellants don't want to talk about it. When Congress decided to wade into the field of tobacco regulation, which was something that the states and local governments had done for 100 years, they were really careful. They took a lot of time to create these specific provisions and said in the area of tobacco sales regulation that the states and local governments were still free to enact regulations that were even more stringent or in addition to anything that the federal law did. And we think that that answers the question, period, that you're not even in 337A land because Congress has told the states that they can act state laws like Wisconsin, and many other states did here as well, as the court can see from the other cases litigating this preemption issue here. But even if there's still some piece of 337A left, it doesn't work the way that the appellants tell you it does. Now, they've got a lot of string-cited cases on page 28 and a lot of other places in their brief, but every single case involves a situation where a judge, it's usually in a tort case, is going to have to adjudicate whether there's a violation of some provision of the Food, Drug, and Cosmetic Act. The judge is going to have to get in there and say, is there a violation or not? That's never going to happen in a situation where a state decides to accept a federal permission. So we can go all the way back to the Zook case, right, where you needed that license from the ICC. In Wisconsin's law, it's you show up with your pre-marketing authorization order from the FDA, and we accept that. We don't look behind it to decide if they violated some provision of the Tobacco Control Act. We're like, great, you've got the order, you're done. None of the cases they cite are about tobacco sales regulations at all, except for that one Iowa case that's on appeal for the 8th Circuit. But other than that, none of these cases are about tobacco. So first of all, we don't think we should even be in 337A. But even if we are, they are stretching 337A far beyond what it's been doing, what it's done in the past. And I think it's telling that the reply brief focuses on amicus briefs from the United States, where the court decided not to adopt the positions the United States was taking there. I also want to go to their, what I'm going to call their enforcement vibe argument that we see in their...
Before you move on, could I ask you something? That certainly may be true for subpart A, that is the marketing authorization. Subpart B talks about when the electronic vaping device was marketed in the United States as of August 8th, 2016. Could there be a dispute as to that the regulated party might come to state court and say, look, we did market it, and the state thinks we didn't, and so therefore, we think we're fine under subpart B, and so state court adjudicate that issue for us. Does that have the potential of creating some sort of conflict with an FDA determination as to the date of marketing?
We don't think so, Your Honor. Again, we're looking for that piece of paper that they had put in an application and that it's still pending. The FDA actually maintains a list of those. Now, could there be things where people say, well, we didn't think we had to put in an application, or we have some reason? Perhaps we're ending up with fewer products that are on our list than could be, but that's okay, because the savings and preservation clauses tell us that we can have laws that are more stringent. So if there are some people out there who said, well, we didn't need to apply, so we didn't, they just don't have the piece of paper, and we don't look behind that. Okay, so getting back to their enforcement vibe argument, we think that that's really too broad a net to cast. And that goes all the way back to Zook and also the Kansas v. Garcia case from the U.S. Supreme Court, where the court has been very clear that a simple disagreement about enforcement priorities between the feds and states isn't enough to find preemption. And then last, to the extent this court even gets to the beyond the merits phase, which of course in our circuit, we don't find a strong showing in the merits, this court can stop right there. But if this court went on to the balancing of the equities, we think those strongly counsel against an injunction here. We have the harm to the state in enjoining a validly enacted state law. That law was passed in December 2023. And not only is that a regular old law, but it's a public health law that has taken products off the shelf. This is vast majority of this product, the facts are in the record, flavored product that's really appealing to kids and teens. This is getting new vapors, new smokers into the market. And at least so far, what the FDA's experts are saying is that the public health risks for that new group of smokers outweighs any benefits to transitioning smokers who like bubble gum and birthday cake vape as a way to stop smoking. We also have on the other side of the harms, we have the appellants who are selling less product now, and that's what the district court found. But at deposition, they told us we didn't take any efforts to find different products. We didn't take any efforts to expand what we sell or to look for those legal products. And they told us that actively, and these depositions took place I think a month before the law went into effect, they were still restocking illegal products. So to the extent you're losing money on product you were buying up till the right second, you may be harmed, but the equities aren't in your favor. Next, we have their delay in bringing suit. Our law was enacted, as I said, in December of 23. They waited until 8 weeks before it went into effect, which was September 2025. So they brought their PI in July of 2025. And the Supreme Court has told us, if you want the emergency extraordinary relief of a preliminary injunction, you've got to be diligent. You can't tell us you have an emergency when the emergency is of your own making and lack of diligence. They've never offered us a reason for that. In their briefs, they talk about lack of prejudice to the state. The cases they cite are about latches. Prejudice is relevant to a latches defense. It's not relevant to the question of entitlement to preliminary injunction under the equities factors. And finally, under Shandell, we also think they have unclean hands, because what an injunction from this court or the district court would have done is to enable them to continue buying and selling a product that's illegal for sale under federal law. Is there no further questions?
Thank you, Ms. Gibson.
Thank you so much.
Mr. Fraser, we'll go back to you. We'll give you 3 minutes for rebuttal.
Thank you, Your Honor. I appreciate it. First, on counsel's point on the baby formula example being different, the state's argument is that if a product is illegal, there can be no standing. When the FDA exercises enforcement discretion over any product, that does not make the product legal. Congress decides what's legal and what's illegal. The executive branch cannot say, well, we've decided this is legal and we're just going to let it on the market regardless of whether it complies with the statute or not. So that distinction doesn't make any sense when we're talking about whether there's standing or not. Counsel mentioned that we don't want to talk about the TCA. I'm very happy to talk about the TCA because it's important to look at the original TCA and what was Congress doing when it passed the TCA. This was the first time the federal government was going to regulate the sale of cigarettes other than labeling and taxes, things like that. And when Congress passed the statute, because cigarettes are bad, It's the only product that's legally on the market today that, when used as intended, kills many of the people that it uses. Now, you might think, well, why doesn't the government just ban cigarettes then? The TCA actually, and it's in 387G, I believe, 387 lowercase g, actually tells the FDA you cannot ban cigarettes. Tells the FDA that you cannot require nicotine yields to be lowered to 0. And that's important when trying to figure out what the preservation clause is for in the TCA, where Congress was saying, we're going to allow some of these products to remain on the market, but if you want to go beyond that, states, you are free to ban cigarettes if you want to. You are free to reduce nicotine levels to the level to 0 if you want to. The TCA specifically leaves the authority to the secretary to ban menthol flavored cigarettes, but does not require him to do that. But states could be free to do that as well. The TCA in section 387 lowercase a-1 required FDA to adopt regulations that the FDA had tried to adopt in the 90s when the FDA tried to regulate cigarettes as a drug, which set a minimum purchase age of 18 to buy cigarettes. The TCA required FDA to readopt those regulations, but the preservation clause, what it does is it allows states to raise that age to 21 if they wanted to. I'm running out of time here. So, any questions, Your Honor?
No, thank you very much. Thank you, Mr. Fraser. Thank you, Ms. Gibson. The case will be taken under advisement. The court's going to take a very brief recess. We'll continue now with Appeal 25-1546, Jezior versus City of Chicago. Mr. Fox, we'll begin with you.
Good morning, Your Honors. My name is Ed Fox. I'm representing the plaintiff and appellant in this matter, Michael Jezior. This case is here following the grant of a summary judgment in favor of the defendant, the City of Chicago, which is through the fire department. Jezior was, this is an ADA case, and Jezior was a member of the fire department, a longtime member of the fire department, when in 2013 he had a stroke. Following he had the stroke, he had some disabilities in his leg and his arm. His movement was restricted, and he was unable to continue doing the typical firefighting duties of fighting fires. In 2014, through the fire department, Jezior applied for and received an accommodation to work at the airport as a procurement officer. This required him to do certain office and procurement duties and work on the computer. It's important to note that this is an established position at the airport. The duties did not have to be modified for that position for Jezior to do the job. He was accommodated because they gave him that position because he was able to physically do that job. Previous to him taking that job, Mr. Jezior taken the lieutenant exam, and he was put on a promotion list. Roughly 7 years after he started that job as an engineer paramedic, his number came up and he received a promotion. He was set to be promoted. Everybody in his chain of command, including his supervisor, people in human resources, and others were expecting him to go to the academy and come back to them. But on his first day at the Lieutenant Academy, Commissioner Ford saw Mr. Jezior at the academy, and Commissioner Ford saw that he was disabled because he had walked with a cane, so forth, and he then denied his promotion without having any discussion with him about the job he was doing and the functions of it, or without regard to any other jobs in the fire department that somebody could do as lieutenant, of which there were many. Jezior had been, as I said, Jezior had been doing this job for roughly 7 years as an engineer paramedic in that rank. Primarily, this case is about the defendant not accommodating him into that position as a lieutenant. The defendant is given two shifting reasons for the denial. Commissioner Ford was
counsel, is there a requirement that the fire department accommodate him in that job at that rank, as opposed to offering another job at the same rank with accommodations?
There's no specific requirement that they have to give him that job. The law says, and what should be filed, is they're supposed to reasonably accommodate him if it's reasonable to do so. And that's what this case is about, the reasonability of being able to accommodate him into that job as a lieutenant. And the defendant's given two shifting reasons for the denial. The Commissioner Ford, as I indicated, was a decision maker, and what happened was he told Brian Helmholtz, who was a deputy fire commissioner, that he was denying the promotion to tell Jezior that. According to the deputy fire commissioner Helmholtz, Ford told him he wouldn't allow Jezior to stay in that same position in the airport as a lieutenant. Contrary to this, though, Ford testified in his deposition that he denied the promotion because Jezior was disabled and that he didn't receive medical paperwork indicating Jezior could work as a lieutenant in any job because of his disability, even though he's perfectly suited to the job he had been doing, and there are other jobs in the fire department that lieutenants could do without having to fight fires. Following the directive from Commissioner Ford, Brian Helmholtz then set up a meeting with Jezior and his union rep to discuss the situation and the denial, and Helmholtz indicated he would try to get Jezior a different job at the Fire Prevention Bureau that he could possibly do.
Is that a mobile job? I'll be asking the same question to the city. It just strikes that the Fire Prevention Bureau, it seems to me the person's got to go around and check these things out, right?
Right, and there's different jobs there, and you're...
Oh, there's different jobs there. Okay.
Right, but many jobs do require inspections of buildings, climbing stairs, and doing the sorts of things, some of which Jezior could do, other things he could not do.
Okay.
Helmholtz testified, but when asked at his deposition about why the promotion was denied, Helmholtz testified at the airport, he testified that there was no budget line for it, so he gave a different reason than Ford did. The evidence in this case overwhelmingly showed that both of those reasons, whether it was because the Ford's reason he was disabled or that there was no budget line for it, are pretextual. Budget lines for promotions are routinely solved by various means, including including borrowing budget lines from other departments and restructuring the job descriptions to make it work. This was the testimony of virtually every person that testified to this, including the defendant's witness, including Brian Helm, who made the comment about the budget line, because he testified himself. He was aware of people of budget line situations that were borrowed and made happen. Tim Sampe, a former deputy chief, former district chief, testified at length about how budgets are almost never an impediment, and in fact, he testified at length of how it's done. And a budget line, typically it's done by borrowing a budget from another department or division, or you can restructure job position and make it happen.
Questions about some comparators, or purported comparators. Did McGill hold a higher rank than plaintiff?
It was an odd situation, as I understand it. He had an exempt position, but then he was at the Lieutenant Academy himself, and they wanted him to be able to fill his job. He wanted to be able to get the promotion at the academy to lieutenant for pension reasons that I quite frankly don't understand. But McGill was at the Lieutenant Academy, but he was able to get promoted at the same time to the lieutenant position, but hold his exempt rate position, which was actually higher in the same job position.
And then about Muse, isn't she in a very similar situation as your client? She works the same job as your client, was lieutenant, was told her position was civilianized, so she left. Is that the similar circumstance?
That's exactly right. So what happened with that exactly was she had been in that job as a lieutenant, and what happened, they were trying, back many years before, they were trying to civilianize the position. District Chief Sampe told Muse that, and Muse didn't want to, so before she was told she had to leave the position, rather than being told she felt she'd have more power if she just left the position, she just left the position because she was anticipating it to be civilianized. Then what happened was they couldn't get a civilian to do the job. And the reason why it required knowledge and skills that a civilian didn't have, including you had to be FAA certified to work at the airport. Civilians don't typically have that sort of certification, and it takes a long time to get. And you have to be familiar with fire department procedures and methodology of how they do things. And a civilian didn't do that. So because they couldn't get a civilian to do the job, Sampe got Jezior accommodated into that position. And incidentally, Leslie Muse also happens to be Commissioner Ford's sister. And she had that job as a lieutenant just before Jezior had it. And it was a short time they couldn't get it civilianized, so they gave it to Jezior.
Mr. Fox, as I understand the department's argument, it's that a lieutenant, in order to qualify to be a lieutenant, you have to meet certain requirements. It's like 10 requirements. I'm just throwing it out there, 10. The job at O'Hare as procurement officer may only require 5 of those 10 attributes that a lieutenant needs to do, including one being able to respond emergently to a fire situation, right? But the lieutenant still has to meet those 10 requirements. And that allowing Mr. Jezior to work at O'Hare in the procurement position before he was lieutenant was kind of an accommodation to him, because that job didn't really necessitate having to use all of those skills. But as I see it, the department is now saying, look, if he wants to be a lieutenant, he needs to be able to meet all 10 qualifications, because we might move him around, because lieutenants need to do all of these things, and that's how we define the position. And so we shouldn't be held almost like we shouldn't be stopped from saying that we shouldn't be held permanently to the accommodation we provided to him before if he doesn't meet those qualifications. And I think that's kind of the gist of their argument, and I was wondering what your response to that is.
My response is twofold. First, no witness ever testified to that. That's a wholly lawyer-created argument. No witness testified. He has to be able to fight fires, which is one of the requirements you're referring to. He has to be able to fight fires to be promoted into being a lieutenant. In fact, people in many lieutenants in the Fire Prevention Bureau don't fight fires. So it's commonly done. And that's a wholly lawyer-created argument. And
they don't fight fires, but they're able to fight fires.
No, because they're disabled, and that's why they're in the Fire Prevention Bureau, and they got accommodated there. So they don't have to be able to fight fires. And more specifically to your point, District Chief Geis, who is in charge of the airport at the time, testified. This question was asked to him directly. in an emergency, what would be expected of Jezior? He was asked that exact question, and he gave a lengthy description of what would be expected of Jezior, and it didn't include fighting fires. It included things that he could do, set up in a warm zone, and guys talked about what he was expected to do, and guys acknowledged that wouldn't be done, and he was the chief in charge of the airport. And again, there's no witness that says this is why we couldn't do it, because you have to be able to do. Jezior couldn't do all these 10 functions. The lawyers have said that, but not a witness. With regard to the disability reason that Commissioner Ford gave, in addition to the fact, and I'll come to this, he said several contradicted things, and his credibility is really not good here. He said that he wasn't given the job because he was disabled, and that there were no jobs for that. And as I indicated, his predecessor, Muse, his Ford sister, did the job, and she wasn't fighting fires in that job either. With regard to the district court's decision, I want to get to this because the district court's decision was that Helmholtz, in his dealings with Jezior in his conversation, indicated he would try to find Jezior a position at the Fire Prevention Bureau he could do. It was an unknown position with unknown requirements at that point in time when they were discussing it. And subsequent to the conversation, Helmholtz sent an email to Jezior's union representative, Buckus, and said, look, I'll offer him a position at this is in the email which we've quoted, I'll offer him a position at the Fire Prevention Bureau. We don't know what the position is, but provided he's medically cleared to do it. If Jezior, and this is the important point and why the district court was wrong on, inaccurately characterized the facts on this point. If Jezior chose to accept the promotion, take his chances, go to the Fire Prevention Bureau, and if he was not medically cleared to do the job, he would be forced off the department and forced to retire. He had that choice, or the choice was stay where you are in your now current job as a procurement officer, and you won't get the promotion. That was his choices. So when the district court said it's puzzling that Jezior was uninterested in the job at the Fire Prevention Bureau because he was offered that, that's not exactly true. Jezior was uninterested in risking his career with the fire department, and we laid these facts out at length. It's paragraph 78 in our statement of facts. We discussed it in our brief. He was given that choice, either take the job at the fire, an unknown job with unknown requirements, and if you can't do it medically, then you'll be forced off the department or keep your current job. And that's...
Would you like to save the remainder of your time for rebuttal?
Yes.
All right, thank you.
Thank you.
Thank you, Mr. Fox. Mr. Merrill?
May it please the court. Plaintiff filed suit against the city alleging violations of the Americans with Disabilities Act because the city did not create a new lieutenant position in the budget that would allow him to be promoted to a higher rank and receive the corresponding increase in salary, but continue to do the exact same work he did prior to his promotion. Federal law requires no such thing, especially because plaintiff was not even a qualified individual to work as a lieutenant in the Bureau of Operations. The district courts correctly granted summary judgment on both of his ADA claims, and this court should affirm.
A couple of questions, Mr. Merrill. The idea of an exempt rank position, what does that mean, and what makes that different from the position that Mr. Jezior held?
Yeah, so my understanding is exempt rank positions are top management positions where you can be appointed to them kind of separate from the collective bargaining agreement. So they're not subject to nicely the same promotion and procedure requirements of how you become go through the career ranks. They're kind of top level positions that are appointed and then removed potentially on different administrations and when new fire commissioners come in. So it's a completely different factual situation. What happened with McGill that you were asking with is you can still progress kind of behind the scenes, let's call it, at your career rank, so that let's say when a new administration comes in, you get knocked out of your more senior exempt rank, you still fall back on whatever career rank you're then on, including for pension purposes thereafter. But in the case of McGill, he never changed position, he never changed ranks, he never got increased salary from this kind of, what's called paper promotion to lieutenant, because he was always occupying this higher level position. That position had to be that rank, that higher exempt rank.
Same follow-up question that I asked Mr. Fox with regard to the Fire Prevention Bureau. It sounds like there are aspects of that position that might require mobility and might be implicated by Mr. Jezier's physical circumstances, and there are other ones that would not be. Is that fair?
Yes. What is clear from the record is the plaintiff himself acknowledged that he knew people who were in wheelchairs who worked at the Fire Prevention Bureau. Certain locations had ramps and other accessibility or things. When he talked to the city's disability officer, she talked about there could be additional accommodations that could be in place. I think it's important to understand that when we're talking about transferring to the Fire Prevention Bureau, that's not in lieu of any other potential accommodations he could get. There could be additional accommodations on top of that to make sure he's in an assignment that he could perform. But that kind of bureau, that non-operational bureau where people are not required to be capable of fighting fires and other emergency responses, is the only place where those type of accommodations could realistically be made. So just starting off on both the claims, the accommodation claim and the disability discrimination claim, he does not meet the requirements under the ADA of a qualified individual. Here, it is undisputed that all uniform positions within the Bureau of Operations require employees to be capable of firefighting duties. Plaintiff admitted to that in their response to the city's statement of undisputed materials facts. That's docket entry 115 at paragraph 6. And it is based on witness testimony. It's based on Helmholtz's declaration stating that as such, so it's not just a lawyer-made statement. And plaintiff also admitted that there is no possible accommodations that would allow him to physically perform firefighting duties. That's docket entry 115 at paragraphs 46 and 47. So those two admitted and undisputed facts are frankly the beginning and end of both claims before this court because they establish that he's not a qualified individual. Everything else is either further elaboration or alternative bases to affirm judgment. Now, plaintiff tries to get around this conclusion but he avoids the relevant legal issue. For example, he argues that his particular desired assignment at the airport shouldn't involve firefighting duties. But that confuses the essential functions of the position, that is a uniformed firefighter or a lieutenant in the Bureau of Operations, with the responsibilities of any particular assignment. As this court explained in Tate v. Dart, with respect to lieutenants who worked at the Department of Corrections, whether a particular assignment would mean that an employee might never need to do an essential function of lieutenant, that does not answer whether being able to do so remains an essential function. In fact, both this court and other circuits often point to firefighters as the paradigmatic example of emergency response positions that have essential functions that certain employees might rarely if ever perform, but they remain essential functions nonetheless. In addition to not being a qualified individual, Jezier's failure to accommodate claim fails because we did offer him a reasonable accommodation. He was offered the opportunity to transfer as a lieutenant to the non-operational Fire Prevention Bureau. Jezier not only rejected that proposal, but he also just shortchanged the interactive process by refusing to entertain anything other than his preferred promotion at the airport. From the beginning, Jezier wanted one and only one accommodation. That was the in-place promotion where he could get more pay, hold a more senior rank, but do the exact same work. The city was not required to acquiesce to that unreasonable request, and he refused to entertain any other alternative options. In fact, the city's disability officer proactively reached out to him to discuss the issue, and he rejected her assistance, explicitly telling her that he was not going to submit an accommodation request with the city, and instead taking his chances with the specific job he wanted in the future when there was a new fire commissioner coming into office. That posturing is antithetical to good faith participation in the interactive process, and its failure falls at his feet. For these various reasons, as well as those discussed in our brief, Jezier has failed to establish a prima facie case of discrimination. But in addition, his claim also fails because the requested in-place promotion would have caused the city undue hardship. Indeed, an employer doesn't need to show any hardship when the requested accommodation requires the creation or recreation of a position. That is because an employer only needs to accommodate people in vacant roles. Here, there was no vacant lieutenant position at his current work site to do procurement work. That was eliminated after lieutenant as part of this civilianization effort. A fact that Jezier expressly admitted when he stated that he expected a new budgeted lieutenant position to be created for him. That admission is found in docket entry 115 at paragraph 76. And in any event, forcing the city to roll back publicly announced multi-departmental efforts to civilianize certain fire department functions constitutes undue hardship. I want to address the medical clearance issue because it was brought up with opposing counsel. Medical clearance is standard practice for new hires, employees returning from FMLA leave, and employees requesting accommodations. It simply requires a medical examination that ensures that an employee can safely do certain essential functions of a job with any approved accommodations in place. So it's completely speculative that plaintiff wouldn't have been medically cleared to do some assignment at the Federal Fire Prevention Bureau, in part because it's unknowable what other accommodations he could have requested and received at that bureau if he had actually continued on with the interactive process. And as I said before, he admits that he knew individuals with wheelchairs who worked at the Fire Prevention Bureau. So the medical clearance requirement doesn't transform the offer to transfer their lieutenant into something unreasonable. And just to briefly address his separate disability discrimination claim, for the reasons we've already discussed, that claim also fails because he's not a qualified individual. But in addition, plaintiff has no evidence that he would have received an in-place promotion but for his disability. On the contrary, we wouldn't even, if he wasn't disabled, we wouldn't even be having this conversation because newly promoted lieutenants by default start as relief lieutenants where they are assigned to operational openings. So in the normal course of business, new lieutenants don't get to stay in the same assignment they held prior to the promotion and do non-operational functions. In other words, plaintiff is asking for something special in this case, which, separate from the accommodation claim, but that's not to be treated the same as a non-disabled, newly promoted lieutenant would normally be treated. Also, for the reasons we discussed in our briefing, plaintiff has no evidence of pre-tech or similarly situated firefighters. I'm happy to address any of those arguments beyond our responsive arguments in our briefing, but if your honors don't have questions about those responsive arguments of ours.
Counsel, one of the arguments that Mr. Fox makes is that Mr. Jazier didn't want to take the risk to be transferred to the Fire Protection Bureau because he thought that if he didn't pass the medical clearance requirements, that he would be forced into retirement. Is that a realistic risk? Was that a reasonable consideration for him to have had?
I think it's for the reasons I was discussing with the medical clearance requirement. I believe it's entirely speculative, and there's nothing to believe on the record that it is a realistic concern. But what I'd say is it's not that or his trying to get a lieutenant in his current position. As we've discussed, he was not a qualified individual for a lieutenant in the operational capacity. So in the scenario where there was no amount of accommodations that could be made for him in the Fire Prevention Bureau, that doesn't mean a promotion in his current role would have automatically been required under the ADA. It just meant that there would be no promotion available under the ADA that would require because he wasn't a qualified individual in his current capacity. It's possible under the ADA that there are no positions he could do. I'm not saying that's the case here, but if that one did not pan out for the reasons, it wasn't a promotion where he currently was working as the alternative option. That just wasn't an option.
Thank you, Mr. Morrell.
Thank you.
Mr. Fox, we'll move back to you now for rebuttal argument.
They spent some time talking about he's not qualified because he couldn't do firefighter duties. And just before he said that, he testified about how people are in wheelchairs at the Fire Prevention Bureau. So there might be paperwork that says what you need to be able to do as a firefighter and to be a lieutenant. Maybe on paper it says that. And Helmholtz did say in his declaration what the duties of a lieutenant are, but he was saying in a general sense, nobody said this with specifics to the situation that here in accommodations, and we know they accommodate people because they just said they accommodate people in wheelchairs. And so the argument that he couldn't do the job, he wasn't qualified to do the job is just wrong. And District Chief Geis, the chief at the airport, testified in favor of Mr. Jazier and said he could do the job. He wasn't expected. He would never have to, in an emergency, fight fire.
Mr. Fox, those lieutenants who are in wheelchairs in the Fire Prevention Bureau, do you know whether they were promoted before they became disabled or were they promoted when they were disabled?
I don't know the answer to that question.
Is there any evidence in the record about that? Because it would be one thing if the city or if the department promoted someone to lieutenant when they were disabled, because I think that would put into question their rationale that Mr. Jazier was not promoted because he couldn't meet the requirements. But on the other hand, if those lieutenants were promoted and became disabled afterwards, then that might distinguish their cases a little bit.
I can say this with absolute certainty. When Mr. Jezier got promoted and he went to the fire academy, everybody in his chain of command, because this is in emails, including Brian Helmholtz, including the district chief, including human resources, they all thought he was going to go to the academy and then go back to the airport in his prior job as a procurement officer. It was completely unexpected when Ford came in and said, you can't do the job as a lieutenant that my sister had been doing as a lieutenant. And so so just by inference, if they all expected him to do this, the inference is that it's something that can be done and is done.
So what you're saying is before Commissioner Ford raised the issue, everyone at the academy just assumed that he met all the qualifications to be a lieutenant.
Well, not only at the academy, but his district chief and Brian Helmholtz himself. They're on emails referencing the fact that Michael Jezier is going to go back to the airport as a procurement officer when he's done at the academy. So all these people assume at the inferences that it's expected and it can be done. So I can say that, and that is certainly in the evidence. And then
Thank you, Mr. Fox.
Thank you.
And thank you, Mr. Morrell. The case will be taken under advisement. We're going to move now to Appeal 25-1859. This is Packaging Corporation of America Thrift Plan versus Dina Langdon. And we'll let you get unpacked there, Mr. Mayor, and then you can take the lectern. I had a law partner who, every time I used the word podium, and I should have said lectern, would wag his finger at me and said, "This is a lectern. It's not a podium." So he's not here, but I'm giving him credit anyway. Mr. Mayor, we'll recognize you now on behalf of the appellant.
Yes, Your Honors. My name is Jeff Mayer, and I'm here representing Danae Langdon, is what she likes to say her name. And she is the designated primary beneficiary under the plan that we're going to be talking about, which is an ERISA plan. And the main issue is dealing with substantial compliance and how that applies. But before we get to that, I would like to discuss, because I think there's a jurisdictional issue here that needs to be addressed by the court. And that arises out of the oddities of the way the case proceeded. And the case proceeded normally between the estate of Carl Kleinfeld, the deceased, who was the participant in the plan, and Danae Langdon, who was the primary designated beneficiary. And it went through the administrative process under the plan. And because there was a dispute, then we went into, it was filed, an action was filed. I can't remember what they actually call it off the top of my head. And then as that action proceeded, Judge Peterson recognized that there was another necessary party that should be part of the action. And I really don't dispute that there's a necessary party, and that was so there's a primary beneficiary under the plan, and there were two alternates. And the plan, in my opinion, well, I think everyone's opinion, clearly stated that if there's a deceased, then if there are not any other beneficiaries, that then the estate of the deceased would be the benefit, receive the benefits. That estate would receive the benefits under the plan. In this situation, Danae Langdon was there, which is being argued that she's not a proper beneficiary. And there was another alternate beneficiary that was alive at the time. She was sick, she had been fighting cancer for a long time, but she was alive, and she was actually, at the time, the personal representative for the estate of Karl Kleinfeld. And the plan states that if that's the case, and if the primary is determined not to be the primary beneficiary, and then the alternate who is still alive at the time dies, it's the alternate estate that becomes the beneficiary, receives the plan's benefits. The jurisdictional question comes into play is that whereas all the administrative procedures were exhausted between the estate of Karl Kleinfeld and Miss Langdon, none of them were done with the estate of Terry Schultz.
And then Schultz was given notice, but then Schultz didn't ultimately appear. Schultz's estate.
After the action has begun, right, the judge said, well, what are we going to do? He said, she hadn't even made a claim. She hadn't filed a claim. And the judge said, well, we'll give you the opportunity to file the claim and to provide service for the action since the personal representative for the estate of Karl Kleinfeld, it gets confusing, Kleinfeld was also the personal representative for the estate of Terry Schultz. So we'll recognize that personal representative can accept service on that behalf, and then pursue a claim. And what that personal representative did was accept service, and then she filed a document that says that the estate of Terry Schultz, which was her mom, intends on pursuing a claim. And that was it as far as any administrative procedures were concerned. And that doesn't even qualify as an administrative procedure. I do want to say, the estate of Terry Schultz never filed an answer to the complaint. The only thing filed was that notice that she intended on pursuing a claim.
And counsel, where that I think would have perhaps more of an impact, and this gets into your argument regarding the district court sua sponte granting summary judgment. There's a binary choice that you're asking the district court to make, and that's, does your client, is your client entitled to the funds? And if that answer is no, that's why you're here. It just so happens that if that answer is no, someone else is getting the money. But we are here adjudicating, and the district court did adjudicate, and even before it went to sua sponte summary judgment regarding Schultz, it's answering the question, is your client entitled to the money? What am I missing there?
Well, there were, if you count the sua sponte summary judgment, there were 3 summary judgments. My client is the designated primary beneficiary, and I don't think I'm quite understanding what you're asking.
So you're here saying that your client, as the designated primary beneficiary, is entitled to the proceeds, correct?
Correct. Yeah.
Right. And if there was substantial compliance to change your client from the beneficiary, then your client isn't entitled to the money, correct?
Well, once again, Your Honor.
If there was substantial compliance
in the effort to remove your client as the beneficiary, then your client isn't entitled to the money, correct?
Correct. Yes, so let's address that issue then.
Well, and to me, the other issues, they just flow from that. If there was, okay, if your client doesn't get the money, then there's three other, potential claimants, then perhaps there's more procedure that is due to figure out which one of those potential claimants should receive the money. But once the district court has determined whether or not your client is entitled to the funds, we've effectively answered the only question that's before the court.
There is the administrative procedures, Your Honor, that we don't know for sure what the plan administrator would determine. And then there's the issue of burden of proof, I guess. But I understand what you're saying. So let's talk about it, because I don't think there's substantial compliance in this case.
Tell us why.
And the reason is, the main case, David versus Combs, clarifies that for this to be substantial compliance, there has to be some type of evidence of showing intent, and there has to be evidence that shows that there is substantial compliance with the procedures required to change a beneficiary under the plan. And the intent that is being relied upon is the fact of October 4th that was sent by an administrator, his name is Jordan Wren, HR manager at the, it wasn't sent by the deceased, Mr. Kleinfeld. It was sent by this other person, and if it was sent by him, by Mr. Kleinfeld, maybe it shows intent. But the bigger issue is what compliance there was with the plan's provisions to require for a change of a beneficiary. And the plan is pretty clear. I mean, it's fairly simple, actually. It can be done. It can be done by going online. All the documents sent out in the plan identify the website they can go on to change the beneficiary. It can be done with a simple phone call to the benefit center. Neither of those were done. There's no evidence in the record that those were done. There is evidence that, a couple of years ago, prior to his death, he had made a call to the benefit center, so he knew how to make the phone call, but never made the phone call.
This is with regard to the 2006 previous divorce.
Yes. So there is evidence also, the administrative record shows that he was divorced. He knew the process, the procedures that were required to change a beneficiary. He just didn't do them. And I would have to say that there's kind of a prejudice that you assume that he must have intended on doing it some way. But the Kennedy talks about not getting into specific facts concerning intent, and we could get into all those deep facts as far as why it's believed that Danae Langdon believes that he intended to keep her on as the primary beneficiary. But Kennedy says we don't go there. And the only chip in that armor of not going there is substantial compliance. And the rule says you have to have substantial compliance, you have to have done something that was consistent with the plan's provisions in the plan to change the beneficiary. Mr. Kleinfeld knew what those were, and he just didn't do them.
Would you like to reserve the remainder of your time?
All right, thanks.
Thank you, Mr. Meyer. Mr. Sauer, we'll move to you now for argument on behalf of the appellee.
it please the court. My name is Mark Sauer. I represent the estate of Carl Kleinfeld and the estate of Terry Schultz. The district court correctly found that the federal common law doctrine of substantial compliance removed Danae Langdon as the primary beneficiary of Mr. Kleinfeld's.
Mr. Sauer, let me jump in there because there's a debate obviously between the parties on whether the substantial compliance rule has been satisfied. That is, as Judge Kohler has indicated, really the dispositive question. If we were to go a different route, we've got some issues that arise. This de novo review versus abuse of discretion review, if we were to agree that de novo review applies in a case like this, we could end up creating a circuit split with the Eighth Circuit in this application of the abuse of discretion. And we've got the Kennedy case, as Mr. Meyer has referenced, that the substantial compliance rule could directly conflict with these bright line plan document rules that Kennedy has. So we are, this is one of those Pandora's boxes case where it depends how we open it up, we could have a variety of consequential decisions to make. Are you aware of that? And then what are your thoughts with regard to those consequential issues?
I have thought about those issues, Your Honor, as you might imagine. I read the Kennedy case as acting to a certain extent as a shield to the plan administrator. That if the plan administrator makes a decision based upon its documents, that the law should protect them, or not fully protect them, but it gives a higher standard of review. So, in the facts of that Kennedy case, we have a participant who had been divorced for quite a good long time, maybe 10 years, and then he passed away. And he had taken no steps in that 10-year interim to remove his former spouse as his beneficiary. And in that case, I believe his estate or the other claimants were arguing that that the administrator should rely upon some waiver doctrine in the divorce documents. So this case is different than that because we do have an attempt to change the beneficiary, to remove the beneficiary, I should say.
What are we supposed to make of the fact that Mr. Kleinfeld learns that the facts did not affect the change and didn't take steps after that?
I'm not sure the record fully supports that statement, Your Honor.
Well, there was a period of time there where he was told, if you want to do this, this is what you have to do, and then he didn't take those steps. That makes a challenge to conclude that for all practical purposes, he has done what he had to do, right?
Well, Your Honor, the statements in the record that I've seen indicated that someone had a conversation with him about something. It doesn't really get into what was said or what wasn't said. I know there's an argument out there that he had been divorced in 2006 and he had changed his beneficiary, but the record is very undeveloped as to what the process was back in 2006. It may have been very different back then. So I don't know. It's an interesting question, and I suspect that if this case had not been in the interpleader area that it is, or in interpleader, that we might have a different result. That if the plan administrator had in fact made a decision to distribute the funds, and that the other claimants had brought a claim in federal court for the money or in state court for that matter, I think Kennedy would be much more in play than it is now.
So the cases, a lot of the cases, or many of the cases that talk about substantial compliance, talk about, deal with circumstances where the owner of the policy at least tried or invoked the same procedures, but just didn't check a box or forgot a signature or forgot an address, where there was some technical kind of deficiencies with what was provided. But nevertheless, the owner of the policy did provide or did try to follow the procedures that the plan had put in place. This seems like a very different situation where the procedures weren't even closely followed. And it was like a whole new way of trying to change the beneficiary that was attempted here. What is your response to that?
This is an interesting situation. And one of the things that makes this situation interesting is that, as Your Honor noted, all our other substantial compliance cases usually involve someone who didn't complete the form as required. They didn't sign it, they checked the box wrong, they had some other error, but there's a form, and they did in fact send it to somebody. This is a situation where there is no form, first of all. We have, you can go to call a phone number, or you can go to a website and try and make your changes that way. So we have a participant who did something very different, but one could argue that he actually did something more. At least he did something that created a record or a history of what his intention was. This wasn't like he went into the human resources office at the factory and said, well, I want to remove my ex-wife now that we're divorced. Please take care of that, and he turned around and left. No one would say that was substantial compliance. Here, he went into the office, he caused or asked, I assume, someone there to cause a fax to be sent to the plan administrator. So he did at least create a record there, which makes it, in some ways, equivalent to having a form that was incorrectly filled out. He did make a tangible effort to change that beneficiary, and he clearly expressed his intent in doing that. And I think if you look at the timing of everything, he gets divorced in September of 2022. And then in early October of that same year, he causes that fax to be sent asking that his ex-spouse be removed. So there's clearly a very interesting time correlation there. I mean, I don't think anyone really can dispute that Mr. Kleinfeld wanted to remove his ex-wife as his spouse.
That assumes, though, your conclusion. And we're here with an appellate review of district court decision, which made this determination based upon a certain quantum of evidence that it received. And one of the things we're doing is we're comparing and contrasting it to how far other individuals got on that road towards substantial compliance. The Rendleman case, some of these other cases that talk about how far they went. That's really the substantial compliance call.
So, Your Honor, Rendleman was verbal only, I believe. And so I think I hope we would all agree that sending a fax is more than verbal. There's no dispute about I should say there's less dispute when one sends a writing than if one is using words, verbal words. Most of the other cases that I've seen where they find there is no substantial compliance, honestly use state law substantial compliance. This can be a different case, but even just looking at some of those facts, there are situations, the Illinois state case of Dooley, where I believe there was a participant change form that was filled out but was found in an office. There's the Minnesota case Kagan, where very similarly they found a beneficiary change form completely filled out, but it had been filled out 1 year prior and found in a desk drawer at home.
But Johnson is telling us this is federal common law.
Yes.
After 0203. So we're in that slice of not interpreting statutes, but engaging literally in common law adjudication.
Correct.
And there's not a lot of cases, there are some, but not a lot of cases that speak to this. So what we're doing is we're doing classically what a state court would do, of engaging in that common law analysis with regard to how far Kleinfeld went and whether Kleinfeld went far enough.
Kleinfeld certainly went farther than the Dooley case or the Kagan case, in that he transmitted his intention in writing. I would say that when a participant fills a form out but never sends it, we're left with, well, what was their intent? Did they fill it out and change their mind and not throw it away? We could speculate for quite a long time about what that particular issue meant, but here at least we have someone who took tangible steps to communicate his intent to his employer's plan.
Was it the case that for all practical purposes, Kleinfeld had taken an intent and positive action to change the beneficiary?
I believe so, Your Honor.
And well, once you develop your argument rather than offering a conclusion.
He got divorced in September, as I mentioned. And that divorce document provided that there was going to be a split of that plan. And some weeks, less than a month, he caused a fax to be sent that would have mirrored his divorce documents. He even sent those divorce documents into the plan. He asked the plan to do everything that the plan needed to be done in the divorce. So the health insurance was changed, the vision, dental, life insurance. His fax mentioned all of those things, and all of those things were changed. The only thing that wasn't changed was and I'm looking at the fax, which is in page 89 of the appendix. So I think we have to consider that fax as a step in a process. It's the culmination of his divorce.
I'm also looking at Appendix 145 and 146, where the plan's executive assistant calls Kleinfeld after the fax and says, hey, these are the steps you need to do. Those are the things that he didn't do.
Right.
That's where we could have difficulty reaching this conclusion that for all practical purposes, he's effectuated both the intent and the positive action.
And, Your Honor, the case law on positive action is fairly clear that one doesn't have to do everything that one needs to do. One needs to take a positive action to show this is what my intent was. And I don't know if in some of these cases where we have an unsigned form, if the form had been sent in and then someone noticed it and said, hey, you didn't sign the form, you have to sign the form, and that didn't happen, and we could speculate about that. But in those cases, like in Davis v. Combe, this court found that that was substantial compliance. And I don't know in those cases if there is really that much of a meaningful difference between, in what I apologize, you know, what I keep kind of in my mind is we have all these cases that have forms to fill out, and now we have a situation where there is no form to fill out. You can make a phone call or you can go to a website. And my position is, as I'm sure you all are aware, is that a fax is better than calling it a phone number or a website. I think we have to be, of course, careful that we're not comparing to a certain extent, but I think substantial compliance does sometimes call for that.
Well, this is where we get into Kennedy and
Yes.
the idea of plan document rules. And if the plan requires certain things be done and that a fax isn't sufficient, does that apply or not? So that all takes us all the way back to those original questions I had about Kennedy and the split with the Eighth Circuit on some of these questions.
Right. And I know there is the recent Sixth Circuit case, which is factually very different from this. That the Guy case where the beneficiary murdered the participants. But that case does note that Kennedy is not the end all across the board. That the plan documents don't control in every situation. I think we can start with that. And in this situation, we have factually a very different situation from Kennedy, as I've already said. But I don't know that Kennedy, because it's not an interpleader case, really comes into play at the end of the day. Because we're not acting to protect or shield the plan administrator from their actions. Their action was to go to interpleader and ask the district court to make a decision. I see my time is up.
Thank you, Mr. Sauer.
Thank you.
Mr. Mayor, we'll now go back to you for rebuttal argument.
Thank you, Your Honors. Kennedy is more than just about protecting the plan administrator. It's about having a process so people know what's going to happen and it can proceed fairly quickly and people can get paid what they deserve to be paid under the plan. And, you know, there's a discussion about the facts. There's no evidence here that that fax was sent by Carl Kleinfeld. It wasn't signed by Carl Kleinfeld. His name was typed on it. You know, and
If it wasn't sent, why would the EA then have called back? Yeah.
We're not disputing that. He probably went in there and said, hey, I don't think that Jordan Wren just did this on his own. Mm-hmm. But whether or not it was reviewed before it was sent and exactly how it was read or typed up, there's no evidence on that fact. The other thing, you know, you mentioned Rendleman. I mean, I think that court did a nice job in saying, you know, there really are two types of cases here. One that they always complete with everything, according to the provisions of the plan, and those that don't do hardly anything. This is not a case where Mr. Kleinfeld nearly completed what was required under the provisions of the plan. This is, if this falls into that category where very little was done, and substantial compliance does not apply. Another point I wanted to make was, you know, Council was talking a lot about the facts being different. The further you go down this road of substantial compliance and away from Kennedy, the more burden is placed on the plan administrator. The plan administrator is put into a position where how much investigation do they have to do? Do they have to go outside the plan and look at the facts? And I suggest that the cases say no, that you look at what was done under the plan provisions to change a beneficiary, and if substantial amount was not done, substantial compliance does not apply.
Thank you, Mr. Mayor. Thank you, Mr. Sauer. The case will be taken under advisement. We're going to move now to our final case of the morning for oral argument. This is Appeal 25-1304, Villalobos versus Pacheco. And Ms. Kunkel, we're going to begin with oral argument from you.
Yes, Your Honors. Good morning, Counsel. May it please the Court. My name is Kathleen Kunkel. I am one of the attorneys representing the defendants' appellants in this case, Calumet City Police Officers Pacheco, Brasowitz, Guerrero, and Urbanik. As we know, the issue in this appeal is whether the defendants should have been afforded qualified immunity for entering plaintiff's home based on exigent circumstances. And the answer to that is they should. Now, before we launch into qualified immunity, I do want to address a point raised by plaintiff about this court's jurisdiction in case the court has a question about that. There is no question about that. This court does have jurisdiction over this appeal. There are many, many cases out there from this court. I cite Bayon versus Berkebile, not in our brief, but just for purposes of today, 29 Federal 4th 850 7th Circuit 2022, that says that qualified immunity may be appealed as an interlocutory order so long as the case involves an issue of law. If there are disputed issues of fact, then this court would not have jurisdiction. I submit to you there is no dispute of fact, although plaintiff argues that in their brief. If you really look at the record and what we have, the facts as we have presented them in our brief, the facts are not disputed.
Let me examine that with you, and this is going
Yes.
to go to your opposing counsel as well. The record here, docket entry 168, 175, 178, has a lot of lurking disputes of fact, some of which were acknowledged by the district court, some of which were not, with regard to the timeline, with regard to what happened at the knock on the door. Now, we've got a portion of this case where we know there are issues of fact that are going to go to trial.
Yes.
So we're limiting our discussion to the unlawful entry component.
Right.
Even within that, the nature of the 911 call, the individual throwing the knife, details about how the parties had that officer encounter. We've got the parties submitting factual predicates,
Mm-hmm.
and then we've got disagreement about those, but we also have a factual predicate that's been developed by the district court, which doesn't seem to have acknowledged a lot of the factual disputes here.
Well, and Your Honor, that was going to be one of my points, is that as plaintiff referenced in their brief, they had a cross motion for summary judgment on this entry issue, which was granted by the district court.
And I'll be asking them about that, but...
So one of my points was going to be, at least the district court found there was no dispute of material fact, right?
What if the district court was wrong on that? And if
Well-
the district court was wrong on that, and there are disputed issues of fact, doesn't that go to our appellate jurisdiction?
It does, but I don't think the district court was wrong in terms of determining there was no issue of material fact, right?
On the unlawful entry component?
Correct, on the unlawful entry component. I know plaintiff argues in their brief that we omit certain facts, we slant the facts in our favor. I believe our brief is very just the facts, ma'am, type of brief. The one fact that our officers testified to that plaintiff disputes was that when our officers knocked at the door, they heard a woman's voice from the other side of the door say, no, go away, we're okay, something to that effect. I can't get the door open. She wasn't able to open the door. Plaintiff testified, no, it was me at the door, a male's voice, right? Saying, no, we didn't call police, everybody's fine here, we don't need your help, go away. And that's in plaintiff's First Amendment complaint that he wrote himself as well, that it was him and another male. We give that to plaintiff. We say, even if it was a man's voice who answered the knock and said, no, we're fine, go away, it's still kind of irrelevant to this issue of exigent circumstances. And there are cases out there that I've seen preparing for today where police knock, somebody inside says, no, we're fine, go away, nobody called for you, but they are still entitled to qualified immunity based on exigent circumstances, based on the facts that are known to them at the time. Sorry, Your Honor.
No, that's fine. So, stepping back, qualified immunity, once it's invoked, defendant has to prove that there is a constitutional violation of constitutional right, and that right was clearly established as a matter of law, right?
Yes.
So here, I take it that for the purposes of this appeal, you are not contesting the district court's conclusion or partial judgment in favor of plaintiffs that there was unlawful entry.
We are contesting that, Your Honor.
Because if you're contesting that, then we lack jurisdiction. So I assume, right, because if you are contesting the district court's grant of summary judgment, that is not what the interlocutory appeal with regard to qualified immunity is designed for. It is, you have to assume that there's a constitutional violation, aka that you have to assume for the purpose of appeal, I know that you're disputing it, for the purpose of this appeal, you have to assume the district court's right that there was a violation of plaintiff's constitutional rights. And then you have to argue that it was not clearly established. I don't see any of that argument either in your brief or, frankly, in the plaintiff's briefs. In fact, even looking in the briefs in the underlying before district court, I don't see any of that argument either. So, and that's why district court didn't even address that second element, which completely puzzles me until I realized that neither side really raised it. So I'm not quite sure what to do here.
And Your Honor, as I was preparing for today's oral argument, you're anticipating where my next argument was going, which is exactly that. I was going to say, and I'm going to say it now, for this qualified immunity analysis, as Your Honor just said, I wanted to take a step back, and I wanted to talk about why the trial court's analysis was incomplete. The analysis, as you've just said, is more nuanced, and I would ask this court to engage in that analysis here. It's not just whether the right was clearly established at the time. You have to take it one step further, right? And when the Fourth Amendment is implicated, as is here, whether qualified immunity applies is a fact-specific, fact-dependent inquiry. This is a quote, "Specificity is especially important in the Fourth Amendment context where the Supreme Court, has recognized that it is sometimes difficult for an officer to determine how the relevant legal doctrine will apply to the factual situation." That's the end of the quote. That's Mason Funk versus City of Neenah, 895 Federal 3rd, 504 at 508, this court, 2018, quoting Casella versus Hughes, 138 Supreme Court, 1148, 1152, also from 2018. And I'm getting to my point here. Another quote, "Police officers are entitled to qualified immunity unless existing precedent squarely governs the specific facts of the case at issue." That again is Mason Funk at 508, quoting Casella at 1153. And that burden of showing a case that squarely governs the specific facts of the case is on plaintiff, or I suppose sua sponte on the court, but plaintiff has the burden to show a factually analogous case that shows that the officer's conduct was a knowing violation of the law. And that's where I'm saying it's a little more nuanced than just to say clearly established right. And the case law is out there that a party or a court cannot simply say, well, Fourth Amendment, grand hand wave. Fourth Amendment, of course, precludes warrantless entries. Those are presumptively unreasonable, right? But with the exigent circumstances analysis, Fourth Amendment, it has to be very fact specific
and time specific to 2015. And
Correct. And our cases, the cases that we've cited, have said, look, there is some delay between a report of illegal conduct and what the encounter the officers have. I think that's Huddleston. But regardless, we provided cases that we felt were analogous to support our officers' conduct, right? Nobody, back to Judge Lee's point, nobody, not the court, not plaintiff, even in our research, we have not found a case that squarely puts these officers on notice that when you use your discretion, when you take all the information known to you at the scene, and you use your discretion to decide, we're going to go in on exigent circumstances to ensure the safety of the people in this home, that they should not have qualified immunity for that. That they should know that that decision is unconstitutional and a violation of the law.
thank you, Ms. Kunkel. Mr. Smith, we're going to move to you. You can anticipate where we'll be going with our questions. Let me start you off. You argue that there are genuine issues of material fact on the unlawful entry claim, that segment, which would defeat our appellate jurisdiction. District Court granted summary judgment to your client on that same claim. What are we to do with that?
Well, first of all, I'll just give you a classic example of there would be situations where we wouldn't have even filed a cross
motion for summary judgment. For instance, if the case was the same, where the police go to the door, but they claimed that there was a woman there screaming, "He's trying to kill me, he's trying to kill me, he's trying to kill me," and our theory of the facts were that never happened. There was no woman screaming, "He's trying to kill me, he's trying to kill me, he's trying to kill me, he's got a gun," those type of things. And then we would have a disputed fact. What happened in this case is we had a situation where we clearly know that the basic Fourth Amendment right to not have your home entered into without a warrant was violated. The classic rule. But we also had a situation where the invented facts of the defendant officers did not rise to exigent circumstances. So we could take their facts as it was and not even argue against them for the purpose of saying, this is not exigent circumstance. This is not an exception to the general rule.
But can we build this court, this panel, build a decision on a factual predicate that's incorrect? So even if you were to assume everything they say and say that there is no appellate jurisdiction here, if the district court didn't appropriately take into account things like the nature of the 911 call, the details about the officer's encounter, or these lurking disputed facts about the timeline of the incident and what happened when the officers knocked on the door. There are a lot of facts here, both that the parties disagree with and that the district court didn't reflect in its decision with regard to the evidence that was submitted before them. So for us to make a pronunciation on qualified immunity on such a tangled factual predicate, do you think we can do that?
Well, first of all, I don't agree with that assessment. The court had all the briefs, all the facts in front of them. The court simply took those facts and focused on the fact that there was no active emergency going on. They're trying to use a stale 3-day-old incident as an active emergency just because we have some facts about an incident with a person with a knife in the alley that we don't even know is a crime of any kind. So the court did have those facts. In its ruling, it just explained how this was not exigent circumstance. It wasn't even close to a burning fire. It wasn't even close.
Counsel, you have examples of what it's not,
Yes.
right? Huddleston, the court found that entry was reasonable. You have a lot of cases where the court said that there were exigent circumstances, that the officers did act reasonably.
Right.
On these facts that you're saying you accepted as true below, what's your best case that the officers violated a clearly established right?
Well, first of all, Hawkins versus Mitchell was a very similar case that was cited from 2014 in this district, right before our case, which dealt with an issue where there were prior domestic violence calls being made where there was actual domestic violence, and then we had a situation that was new, that was even a little tangentially related to it, where they came to a new call, but it was just a verbal argument, so the court said, hey, you're not going in there. There's nothing here that is urgent. There's no sense that somebody's being killed or harmed or maimed here. And that's very similar to ours. But again, we're in a situation where we have the rule, Payton versus New York, the Fourth Amendment. We're up against the entirety of exceptions, and exceptions are not the rule. And Huddleston specifically supports the plaintiff, absolutely, because Huddleston was a case where you had somebody call in that day and say, my daughter is being threatened to take her life. And you had information that the person who threatened her life was still in the home with her, with a gun. That is an active emergency. There is nobody who even tries to come into court and say, hey, we had a 3-day-old incident. So there's no case law that's going to be specific to Mr. Eli Villalobos's case, because nobody's sitting here saying, hey, let's go in because we had a call about this guy 3 days ago. That is not a situation that is even arguably an active emergency, which is why there's not 100 cases on it. You can't turn an exception into the rule. You can't piece together a few facts that overlap with our case and say, oh, now, what are you going to say about that? You're missing the key component of exigent circumstances, that there was an emergency, not some, maybe somebody could think, some theoretical thing. We had the opposite. We had a guy outside alone, and we had the people inside who came to the door and said, get away, we got our Fourth Amendment rights. I mean, that's just dead on. And then even by the time they go in, they even talk to everybody. They never even asked about a woman in distress. They talked to the people, they knew who they were, and they still entered.
So let me ask you, if we agree with you that there are issues of fact and no appellate jurisdiction, doesn't that mean the district court got it wrong by granting summary judgment to your client on that claim?
No, as I've stated,
how can both be true? Because
not every issue is material to the facts that support the plaintiff's theory.
But it's still the unlawful entry claim.
It's the same claim, but just as you could have different offenses to a crime, you could have different reasons why somebody isn't there. So they can't sit here and claim that false facts to try and convince you that this should be qualified immunity, but we're entitled to say, hey, we accept your facts as they are, and as I said, there's hundreds of times we never would have asked for summary judgment. We asked for summary judgment because we looked at their excuses and we said, there's no emergency here. And so even if they're different, they're always different versions of facts. They're always different versions of facts. It's whether it's a material fact that they have raised as to what happened that raises to the emergency exception. And they didn't do that. They didn't do that. When they go in and say, we thought maybe there was somebody at the door who was having trouble getting the door open, that doesn't raise to a kidnapping because a guy was outside, we just saw him walk in the door. We found out that people left through the back door. We talked to the people and they said, yeah, everybody's okay. Oh, that's my girlfriend. All those facts undermine this idea of, well, somebody said the door was unopenable. We don't agree that that happened, but that doesn't mean that we can't say that their story doesn't raise to the level of an emergency, and that's just what the judge found. The judge doesn't have to state every reason ever invented to attack or agree as long as the basis, he applied the law correctly. He looked at Payton versus New York. He looked at McNeely versus Missouri, which gives you the actual examples of exigency. He looked at Hawkins versus Mitchell. He looked at all the facts written. There's nothing in this record that doesn't suggest that that judge didn't read every single fact that was in their brief. I would suggest that he knew it better than all of us. So the fact that you don't have a sentence that deals with an issue is not relevant. And the court definitely does not have jurisdiction to even touch or talk about that in this opinion. Jurisdiction is denial.
I would just say this is a very interesting take on qualified immunity because the elements that are required for QI by the district court were never reached, and then you're indicating to us that that is not a determination that we should review.
Well, first of all, it was never raised by the appellants. Yeah, it is not an appealable issue because it does not end this case. They still would have to be tried. The basis for collateral, when you tackle a collateral issue, it must be complete. There's no completeness here. We'd just be going to trial. And third,
the case is going back for the excessive force trial.
Correct. Right. And so there's no jurisdiction. But as this case is so obviously a Fourth Amendment case that you don't, there was nothing missing to the fact that they violated a constitutional right. They went into a guy's home after saying, "Don't come in." It's right down the middle. And, the fact that in every situation where we present cases, oftentimes we focus on the key issue to a case, and that is what talk about, not obvious issues to a case. You don't spend 4 hours writing an opinion on the history of qualified immunity or on the history of going into homes without a warrant that goes back to 1791 when you know what your issue is, when you know what your problem with their theory is. And the problem with their theory is they didn't have an emergent situation, and they even sat around not getting a warrant for 35 minutes. They didn't get a warrant for 3 days or even attempt to go talk to this guy.
Thank you, Mr. Smith. Thank you, Ms. Kunkel. The case will be taken under advisement.
Thank you.
That will complete our oral arguments for the morning.